Let me please introduce you the presenter in our second session. Our presenter is Professor Gordona Gasmi, an academician in the Serbian Royal Academy, and also the Senior Research Fellow at Institute of Comparative Law, Belgrade. Her paper in today's second session is titled as Country Reports Report of Serbia, the Serbia Country Report on Istanbul Convention. Before we start, I'd like to remind you that we have 30 minutes for your talk. Then we'll move on to questions and answers. Let me remind to dear participants again, questions for the Q&A discussion can be placed into the chat box. You may start your presentation now, Professor. Stage is yours.
Thank you. Thank you for your presentation of my professional background. I was also one of the drafters of the Istanbul Convention on behalf of Serbia. So I'm very glad to speak about it. And thank you for the invitation. My report, we can go to introductory slide. Thank you. Thank you for your support. So my report is based on questions sent from the Istanbul University Institute. First of all, I would like to emphasize that Serbia signed the Istanbul Convention on 4th of April 2012 and ratified it on November 2013. So Serbia was among the first states parties in which it entered into force on 1st of August 2014, of course, together with Turkey. Concerning reservation, Serbia made reservation on the Article 30 because in Serbia there is no state funds for compensation of victims up to now, especially because there is not prepared available official records by the court in court case files. But however, the ratification of the European Convention on compensation of victims of crime with elements of violence should change this situation when it comes to serious bodily injuries or serious ill health. So for the time being, the reservation stays for another 5 years. Also, Serbia decided to withdraw reservation for the Article 44 in respect of territorial and personal jurisdiction. We can go to next slide. Thank you. What is important to say about definition in the legislation that in May this year, Serbia adopted a new Gender Equality Act. So it is for the first time that the legal concept of gender-based violence and violence against women are introduced into legal framework. So here, actually, I have quoted the exact formulation. So we can see that those definitions are completely harmonized with provisions of the Article 3 of the Istanbul Convention. And furthermore, what is important to emphasize that the Chapter 6 of this new law is dedicated to prevention and suppression of gender-based violence. Next slide, please. Family law of 2005 and with the amendments defines domestic violence, but in a gender neutral manner. So it is, as you can see, explained, but through threatening behavior, not through specific types and forms of violence, physical, sexual, psychological, and economic. But the circle of protected persons, family members, corresponds to the definition in the Article 3 of the Istanbul Convention. Also, I have quoted here some very important protection measures that are established by this law against domestic violence, and they are very often, of course, used also in cases of violence against women. Next slide, please, about the criminal code. It's been amended recently in 2016, but criminal code still contains indirect definition of domestic violence. which means that domestic violence implies the use of violence, threat to attack life or body, insolent or reckless behavior that threaten peace, physical integrity, or mental condition of a family member. However, the circle of protected persons is narrower than the standards from the convention. And what is important to accentuate is that this family member who is protected, not the whole family. New crimes in line with the provisions of the convention have been introduced in the criminal code: stalking, sexual harassment, female genital mutilation, and forced marriage. The new law on the prevention of domestic violence that started to apply in 2017 has a harmonized definition of domestic violence in the convention, but however, it's still gender neutral. There is no definitions of violence against women nor gender-based violence against women. Next slide, please. About the definition of violence against women based on discrimination, the answer is positive, yes. Since May this year, in the Article 6, it's exactly how it is actually defined as a violation of human rights and a form of discrimination against women. So in addition to new legislation, in relevant strategies, together with a very new strategy, violence against women is also defined as discrimination based on gender. Here I have quoted some important recent documents, strategic documents. Next slide, please, about the criminal code. They are recognized as special types of crime: domestic violence and violence against women, in the Article 194. However, violence against women is not explicitly mentioned. It is actually amended, the whole criminal code, but with the new forms of violence, actually all of which are still gender neutrally defined. As for the qualified circumstances and punishments, here actually it is important to say that the amendments have improved the punishment of those crimes. Basic form is to be punished from 3 months to 3 years. Also qualified form of domestic violence, which assumes the use of different arms, is to be punished from 6 months to 5 years. An even more serious form of the crime exists if the victim has been inflicted or seriously bodily injured, which means that during the attack, the victim's life was endangered. So, however, this form of crime is to be punished from 2 years to 10 years. And finally, the most serious form of domestic violence is the death of the attacked person. So in this case, prison sentence is foreseen, 3 to 15 years to be imposed. Next slide, please, about the role of victims' complaint. Formally seen in accordance with the Article 50 Criminal Procedure Code, victims have the right to file complaint to a higher prosecutor office within 8 days. So at the beginning, this complaint mechanism was inefficient, but in recent years, higher prosecution offices started returning cases and ordering basic prosecutor offices to continue investigation. Also, it is important to stress that victim support service has been established in higher courts and prosecutor offices in 4 appellate areas of Serbia, which means that they assist also victims in filing complaints. And also law on free legal aid was adopted in November 2018 and it started to apply in 19, and according to the official report of the Ministry of Justice, prevalent number of requests for free legal aid derive from situations of domestic violence. Nevertheless, there were a lot of withdrawal of those requests due to victims' fear, who are mostly, of course, women and girls. Next slide, please. We can talk also about the measures regarding domestic violence and violence against women. It's divided to private law measures and criminal procedure. The provisions of the family law foresee actually protection measures for victims, but due to practice that proved to be very lengthy and inefficient, the new law on prevention of domestic violence of 2017 simplified the procedure, especially in urgent situations of direct danger of domestic violence. So it's foreseen to issue emergency protection orders, to enhance coordination cooperation of shareholders, and to introduce electronic single database of reported cases. What is also important that the family law gives the right to the perpetrator to file a lawsuit for the premature ending of the protection measures. So this means that it transfers the burden of proof to perpetrator, and they have to prove the circumstances have ameliorated. About the criminal procedure measures, there is security measure in form of no contact and the restraining order, which is prescribed in criminal code, and it can be issued together with other sanctions except prison for the period of maximum 3 years. Breach of the measure became a criminal act in 2017. Competent authorities to implement measures are police, prosecutors, and of course the courts. The next slide, please. The role of prosecutor about taking the measures. The family law gives the possibility to request issuance of protection measures, not only to victim, but also to Center for Social Work and public prosecutor. And special urgent court procedures are prescribed in these cases, as well as the possibility of issuance within other court procedures. So based on the data received from the courts, it can be concluded that the number of lawsuits for the protection measures filed by centers for social works and prosecutors are increasing every year. However, the new law on prevention of domestic violence empower prosecutors to actually play preventive role in combating domestic violence. Emergency protection orders are to be issued based on the risk assessment, and also the victim's consent is not necessary. So the authority for issuance of emergency measures has been given only to specialized police officers. They have 8 hours to conduct all the interviews, to gather evidence and assess risk of the domestic violence before issuing a protection emergency order. So eviction from the residence and restraining no contact order. This order from police lasts 48 hours without the right to appeal. It's like urgent measure. And then within this time frame, 48 hours, prosecutors have another 24 hours to request prolongation of the order from the court. So the court have 24 hours to decide on the prolongation with the right to appeal to higher court. Once prolonged, emergency protection order lasts for additional 30 days. So the breach of the emergency protection order actually is to be punished by the prison of 60 days. So this is very important to say. For statistics, I have quoted here different statistics from different official sources. However, there is no unified data and also classified according to necessary parameters foreseen by the convention. we can go to next slide. Important research also in this field were conducted by some women organizations, NGOs, and what is important that especially a law on prevention of domestic violence foresees the establishment of centralized electronic database. However, classification parameters have not been defined. Unfortunately, up to now, this central base has not been yet established. So Gravio, expert independent body of the Council of Europe, actually states that there is a wealth of statistical data, and however, there is a need for uniform database, especially in cases of sexual violence and rape. And of course, it is important to apply it very efficiently. Next slide, please, about the cooperation of responsible authorities. I have quoted here actually the law on prevention of domestic violence, which obliged the establishment of coordination group presided by the public prosecutor. So the obligatory members of the group are police representatives and social service, while other representatives like NGOs and also representatives of victims can be invited to participate. So this group is in charge of develop individual protection plan for the victim, and is to be actually conducted every 15 days. At national level, in line with Article 10 of the Istanbul Convention, Serbia has formed coordination body for gender equality with a mandate to coordinate and monitor multi-agency cooperation. So on the operational level, there have been a lot of efforts to establish multi-agency response to victims of domestic violence. Also, it is important to point to standard protocols for action for stakeholders, and especially general protocol for action and cooperation of institutions in situation of domestic and intimate partner violence against women. So Gravio also noted progress in this field and also invited for adoption of new strategy. Next slide, please. So this is important question about the trust of victims into judicial system. According to the recent surveys, a lot of advocacy relevant awareness raising efforts have been made. So this obviously contributed to the rise of reporting of domestic violence incidents. However, the situation is to be improved. Also, Gravio notes that NGOs have problems in their daily work, especially Roma and women's organizations. So also OECD led research about the safety of women that concerned the violence against women in 2018. Results show very disturbing facts, especially also for psychological violence and physical violence. Actually, generally seen, there is still low reporting rates of women who experience sexual violence and rape. So due to gender stereotypes, patriarchal attitudes, and there is a great need for increased awareness raising in this field. Next slide, please. So what are the measures for increased victims' trust? They are listed in national strategy, recent, and the action plan, and also it's noted through media content, through academic publications. So it is important that Gravio report states the continuation of gender stereotypes, and also the analysis of NGO results you can find in this website that this survey showed that among female very young, there is still actually application of traditional behavior. Next slide, please. We can go to next slide. About the criteria to be applied by investigating authorities for risk assessment. The legal basis is the new law. For the first time, it's been introduced in a legal framework, risk assessment, in line with the articles of Istanbul Convention, especially targeted training for police officers has been conducted on permanent basis by the Academy of Criminalistic and Police Studies. And also special unit of the Ministry of Interior also is formed. What is important to say that police protocol already has existed even before 2016, but has not been so regularly implemented. I will give you an example. For example, in this police protocol, it's been listed what are the forbidden questions for police officers when they come to combat, to regulate the domestic violence case. Forbidden question is, for example, for victim, what you have done to make him nervous, to make him angry, things like that. However, those protocols have not been regularly implemented. It's part of soft law. So that's why the law on prevention of domestic violence is important, and especially trainings that were led. Next slide, please. In criminal proceedings, it is the victim at the center of the risk assessment, which is actually formulated also in criminal code and in the law on prevention of domestic violence. It is important to stress that all those protection measures are targeted to the safety of victim and especially also progress has been made in criminalization of different forms of violence against women. Also, there were several laws and protocols that oblige the stakeholders to provide information to victims on their rights and support services, like, for example, Article 29 of the Law on Prevention of Domestic Violence, Criminal Procedural Code, and finally this general protocol. So this is all important and actually focus at safety of victim. Next slide, please, for perpetrator. Just to emphasize, there is a program of work with family of domestic violence. Perpetrators, it's been implemented since 2011, although Istanbul Convention does not oblige member states, signatories to apply. However, institutes of deferred prosecution were used for referring to treatment. So still treatment programs are not mandatory. So Gravio recommends uniform standards for those programs foreseen in Article 16. And next slide, please. The special measures for children. It is important to stress that the criminal code regulates crimes against children. I have listed those crimes, and what is real situation is that important is to apply more emergency measures in terms of eviction of perpetrator from the apartment and to allow to child to stay with a non-abusive parent, preferably in their own home, and also to receive a special support service in order to suppress post-traumatic stress syndrome, and of course to stay in special shelters for women and children. So all those measures are applied in the practice, of course with the help with the relevant NGOs. Next slide, please. The cooperation of responsible authorities especially with NGOs It is important question. The NGO sector contributed a lot to the widespread idea of gender equality in practice and also in strategic documents. And it is important that they also promoted legislative changes. They did a lot of awareness campaigns, lobbying. So their contribution is very valuable and important. So government counts on their cooperation. There is still a lack of funds to be attributed from budget for their activities, but it is important to say that representatives of NGOs are directly included in working groups for law, strategies, and plans in criminal procedure. Representatives of NGOs participate in a capacity of lawyer who provide free legal aid and psychological support to the victim. However, there is no available data on percentage of this, but they are present. And next slide, please. About the security measures for victims and health and accommodation, there are support services. Those services are run mostly by municipalities or local authorities in cooperation with NGOs. There are also health care services, social services run by centers for social welfare, like counseling, safe accommodation, initiation of court proceedings, financial support, legal, psychological counseling, and finally this telephone helpline, since 2018, national helpline, free of charge, and also additionally at regional level. Next slide, please. About the situation of rise of incidents of domestic violence, it is important to say that it is almost 5% fewer registered events, but this is in contrast with applied measures. So that means that it did not mean that police orders for emergency were reducted. On the contrary, the closure and ban of movement were treated as special risk factors for domestic violence assessments by competent police officers and deputy prosecutors. So last year, police registered almost 9% more risky events, and also larger number of orders were issued, and also larger number of measures for eviction of perpetrator. So also increase in violations of emergency measures by almost 6%, as well as an overall increase of the number of perpetrators of domestic violence by almost 11% compared. So this means that reported events of violence were more serious and more risky due to pandemic, due to those closure and ban of movement. And final slide, please, for the conclusions. I would like to stress that some 2 months ago, Serbia adopted a new strategy for the prevention combating of gender-based violence, domestic violence. In the time frame of next 3 months, action plan is going to be adopted with the necessary budgetary items. So this fact, together with the legal amendments, actually led to the conclusion of harmonization of Serbian legal system with the Istanbul Convention, especially with the forms of violence that were introduced: stalking, sexual harassment, forced marriage, and female genital mutilation that are now criminalized. So Gravio welcome the clear policy commitment of Serbia to eliminate gender-based violence and progress that are made, that is made in terms of integrated response, and of course called for improvement of practice of protection of victims, specifically women and girls, especially in the field of sexual offenses. Thank you for your attention. I remain open for your question, and I'm grateful again for the invitation to participate at Summer Law School. Thank you.
Thank you very much, Professor, for your significant presentation. Now we are moving on to the Q&A section. As a reminder, your questions for the Q&A discussion can be placed into the chat box.
In the meantime, I would just like to add, from the legal point of view, the implementation of this new law on prevention of domestic violence is specifically important because it provided for more effective procedure of protection for victims, especially for women and girls, especially in situations of direct danger, which is defined also in Istanbul Convention. So it is important also that we had a circle of permanent trainings for judges in basic courts and higher courts, and also for public prosecutors, deputy prosecutors who are in charge of implementation of this law. I have been participated as a trainer, and I must say that it's a improvement compared to the existing family law, because procedures were more lengthy and not so effective. So this new law proved to be, with trainings, very effective in the protection and the combat of gender-based violence. And of course, the new, very new law on gender equality 2 months ago was adopted. So it is also important that we have harmonization with convention. Thank you.
Thank you so much, Professor. We can wait a little bit while, if there's any question, it will be loaded up and we could see it over the chat box.
I think it is very important that the topic of this summer school is devoted to the Istanbul Convention, despite of the fact that Turkey withdrew, but it is the honor that the convention bears the name Istanbul. It's been signed for the first time in May 2011. So we really did a lot of effort to formulate. The negotiations lasted 2 years, and it can be said that a standard setting was done. So we can hope that situation maybe will change for that's my wish as an expert for Turkey. But okay, politics is different from the law.
There's a question, let me vocalize it. Thank you for your magnificent presentation. As you explained, and as Grivo report indicates that, Serbia's legislation studies is very positively continuous as Istanbul Convention's necessities. However, how does society reacts to the new regulations in general?
That's a good question. Thank you for asking. There is a kind of a gap between legal professionals who are in charge, of course, for the implementation of new regulations, especially for the law on prevention of domestic violence. Judges and prosecutors are, of course, accepting it very, I can say, eagerly. However, the audience, wider audience, is not quite familiar with all articles, provisions of this new law. As for the gender equality law, I must say that it fostered a lot of negative reactions concerning gender-sensitive language articles. Not so much concerning the part about combat against gender-based violence and domestic violence and violence against women, but provisions about the gender-sensitive language even were let me say, rejected by the National Academy of Sciences and Arts from the specific department, because Serbian language is very specific. It actually, it does not limit gender-sensitive language. But good news for those circles who are, let me say, conservative ones, is that those articles are to be applied only in 3 years later. That means since 2024. So we will see about this. As for the violence against women, this law for the time being, I think is going to be accepted, since it's been also followed by new national strategy. So also many public awareness campaigns were conducted. So I think reaction in general are quite positive, although the wider audience is not completely familiar with all specific provisions of the new legislation. But still, we are progressing. In my view, we are progressing slowly, but we are progressing. So especially for those legislative changes, that is very, but thank you for the question. It's very important also to have support of the whole society. So a lot of work also has to be done more in terms of lobbying and public advocacy of modernization of legislation and of modernization of practice. Thank you.
Thank you very much, Professor.
Thank you. It's been an honor to speak.
Hello, Professor Gordona Gasmi. How are you?
Hello, fine. How are you, Professor?
Thank you. Thank you very much for your presentation. We are very glad, and I hope see you the next conference in Istanbul. We see each other in Istanbul.
Inshallah.
Inshallah. Thank you very much. Inshallah.
That would be an honor. Thank you.
Thank you.
If there isn't any other question, we would like to give our thanks to Professor Gordana Gasmi.
Thank you.
And
Thank you
other,
for the invitation.
You're welcome. And many thanks to all other participants. Now we'll have a break and we will be meeting again for our third session. See you again at our third and last session.